I'm JulieMarion with the First Time Homebuyer Workshop, and today we are so fortunate to have a special guest, Lin Wang. She is a licensed attorney specializing in trusts and estates. She is licensed in the state of New York as well as Minnesota. And so, welcome. I'm so happy to have this conversation with you about how first time homebuyers can protect their very important asset as their very first home. Welcome.
Hi, Julie. Hi, everyone in front of the computers. Very nice to meet you guys. I'm attorney Lin Wang in Trust and Wills, and our law firm can provide service to clients from 28 states all around in the United States, including Massachusetts. Thank you.
Yes, that's great. Well, I think a lot of first-time home buyers, when they're initially starting their home buying process, a lot of the legal stuff happens at the very, very end, and not all people are really aware of how they hold the property can really affect their financial situations and if something goes awry in their life, like a loved one passing away. In other YouTube videos, I've covered definitions like joint tenants, tenants in common, and tenants in the entirety. And so today, if you could sort of talk about some of these different things with that in mind as a starting point, the first time home buyers will have a deed, and then how that really translates into the type of trust that we're going to be discussing. That will, I think, will be very helpful for everyone. Does that sound great?
That sounds perfect. Thank
Okay,
you.
great. Okay. So the first question I have, and let's see here, is what type of trust, and well, let's back up a bit. Can you explain a little bit about wills and trusts and what they do if you don't have them and what they would do if you do have them? How would that work?
Sure. If we want to understand about trust and wills, we have to understand a kind of American legal system called probate, Probate, probate. Basically, if we have assets in the United States, if we pass away, instead that our families will inherit our assets immediately and automatically, they have to go through the probate court to inherit the assets. In the probate court, the government will figure out who gets what according to the legal hierarchy of inheritance. They will find whether we have surviving spouse and children, if not surviving parents, and then surviving siblings, nieces, nephews, cousins, like level by level. And this can be a very long and tedious and annoying process because the government, they need to find the people all over the United States. And like people like me, like I have family in other countries, they even need to verify the relationships from other countries. It can be a lot of work. So yeah, it can take 1 to 2 years to finish the whole process. It requires us to disclose the privacy to the public so the potential people can go to the court to claim their rights. It can take 5 to 15% of the net worth value of the estate to go through the probate. So it is a waste of time, money, and privacy. So we need to have the trust and the wills to say who will get the assets if something bad happens to us.
Well,
We need to keep the rights in our hands instead of the government's hands. So trust and will is a document which can allow us to arrange our assets in our preferred way instead of going through the tedious process of the government. Thank you.
yeah, that's really important, I think, too. And it's expensive.
It is. It can take like 5 to 15% of the net worth of our estates. So
Yeah.
it is really a waste of money to go through the probate. Yes.
Right, right. Understood. So one thing, can you clarify, and I've heard this from a variety of different attorneys, but also just sort of, talking about it within my real estate professionals, that once someone passes, then that trust becomes irrevocable. Is that correct?
Is correct. Because like when we talk about trust, we always say revocable and irrevocable. Basically, the difference between whether the trust is revocable or irrevocable depends on whether the grantor or the person who has established the trust can use the trust property,
Okay.
or whether they can change the rules of the trust. So basically, we have to keep the person establishing the trust alive to make the trust revocable. Because once a person passes away, the person cannot use the assets in the trust property for obvious reason, right? And they cannot change the trust anymore because they already passed away. So any trust will be irrevocable, if any, when the person establishing the trust passes away. And when it is irrevocable, the people in the trust, the beneficiaries, the successor trustees, usually the families and friends of the deceased people, they can only follow the rules in the trust to inherit, use, and manage the assets, but they cannot change the rules because they have to respect the wishes of the people establishing the trust. So that's why we see once the person establishing the trust pass away, the trust will be irrevocable, if any. Yeah.
Okay, so I understand that it's irrevocable. However, if so, let's say it is a husband and wife with joint tenancy. In that situation, then typically that's right of survivorship, right? So, if that piece of property is held in joint tenancy, but it's in a trust, then it would then pass to the spouse that is still alive. Is that right? In whole?
It depends on the situation. Like
Okay.
usually when a couple has trusts, usually they have one joint trust.
Mhm.
It means if one of them passes away, the other one will control everything. The other one can still change the rules in the trust.
Okay.
Because the couple still are alive, like if they are regarded as a whole, because the surviving spouse is still alive.
Right.
In this way, if one of them passes away, the other person controls the assets to 100% extent. And yeah,
Go ahead.
yeah,
Sorry.
yeah. So the surviving spouse will get everything. However, they can choose to have two separate trusts. Some people will choose that way. So the husband will have a trust and the wife will have the other trust. And when they do that, they need to divide the assets. Perhaps they will say this house will belong to husband's trust. That house will belong to wife's trust. Or they will say 50% of this house will belong to husband's trust. The other 50% will belong to the wife's trust. And in this way, this arrangement will break the joint tenancy with right of survivorship. And once one of them passes away, the portion in the deceased spouse trust will control the assets, and the assets will be distributed according to the rules in the trust property. So it really depends on how the trusts are established.
So when someone, when you're buying your first house, I mean, it's so crazy. You're trying to get through the process, you have your work, you have your life, and then you go to closing and then you're moving, right?
Yeah, I can totally understand that. It's
Yeah,
awkward. Yeah.
so this might be an item for the first time home buyers, now the first time home owner to
Yeah.
have on their checklist to do within the first year. I mean, if they can do it before or while they're buying the
Yeah.
property, that's great.
Mhm.
But people shouldn't feel bad, is what I'm trying to say, is just they've bought a house and they still need to take this next step in order to protect their assets, in order to avoid the costly expense of probate, correct?
Correct. Yes.
Yeah. So now what would happen in a situation of joint tenancy? Say you have four friends that bought an apartment building, just to make it simple, and each person has their own apartment. How
Mhm.
would a trust impact that type of legal ownership?
Yes. So, for example, in this situation, like four friends own the house together, perhaps they have the house by joint tenancy,
Mhm.
and we have to understand this. If we have joint tenancy, it doesn't necessarily mean that if one of them passes away, the surviving people will get the other house. It depends on the relationship between the people. So if it's a couple, in most states, including New York and Massachusetts, the survivorship right is presumed in the joint tenancy. So it means if one of the spouses passes away, the house will go to the other spouse. But if it's friends, like for friends, if they only say we own it by joint tenancy, but without the word of survivorship right, then if one of them passes away, the other people cannot get the deceased person's rights directly and automatically. So they have to have a trust to make such arrangements. And I always say, if you own assets jointly with other people, you need to have a trust. And other people need to have a trust as well. Why? For example, we have 4 people owning the house together, but a house is not a cake. You cannot cut it. If you want to sell it, you have to sell it as a whole. No one wants to buy 25% from your hands and own it jointly with other people who I don't know, right? It will be a trouble. So in this way, if they want to sell the house, 4 of them needs to sign off the quitclaim deed to transfer the house to other people. But what if one of them or some of them are incompetent? Or what if they pass away? Then it means if without arrangements, the part in the hands of the deceased people or the incompetent people cannot be transferable. The other people cannot sell their 25%, 50%. They have to sell the house as a whole. So that's why I always tell my clients, if you own assets together with other people, please remember to have a trust. In this way, even if one of you or some of you are incompetent or pass away, the trustee in the trust, usually the friends or the families of the people, can still take over the assets immediately and automatically. So they don't have to wait for a long time to handle the assets. So that's why I say when people own assets together, the trust is always necessary. Thank you.
And so, just to follow up on that a little bit, I mean, I was using an example of an apartment building, but let's say it's a vacation house. And so what happens if someone passes away and so they have their fourth, but property taxes are due, maintenance requirements are due. We happen to live in a snowy part of the United States, but you know, say that there's other situations where is that money is accessible within your trust in order to maintain your ownership so you don't, you know, forfeit it or your creditors don't go after that asset?
You don't have a trust, it's not necessary. Because, for example, I have some clients referred to me by banks. So why banks refer clients to me? Because they want their clients to pay their mortgage on time.
Yes.
Because in some situations, the borrowers pass away or the borrowers are incompetent, but they have a house with a mortgage. Their house still needs to have the repairment. They still need to pay property tax. They still need to pay for house insurance fee for the houses. So who can pay for that? The banks don't dare to take the money directly from the deceased people or the incompetent people's bank accounts because that is illegal. Basically, that's a very simple rule. Without other people's approval, we cannot take money from other people's pocket. And usually the people's family, they are eager to pay off the mortgage. They are eager to pay for the house insurance fees, the repairment fees, the property tax, because they don't want their houses to be foreclosed. However, the banks, they don't have the right to accept the money from such people because they sign the contract with the borrowers instead of the borrowers' families and friends. So it will subject everyone in the situation which are very hard. So that's why they want me to help them. And I always tell them they need to have a trust in advance. And in the trust, they will designate their people, their friends, their families to take over the mortgage, take over the responsibility to pay for the houses when they are incompetent or when they pass away. In this way, even if they are incompetent or pass away, the money can still be accessible and the house can be kept in the good hands.
Oh, wow. Yeah. So you answered my follow-up question. So that's great. And by the way, everyone, she graduated magna cum laude. So she knows what she's talking about. So listen to what she said, here. Let's see here. I did have a couple of other questions. I have to put my granny glasses on, everyone. Um, so what type of trust provides the strongest protection against lawsuits and creditors? The other thing I wanted to mention is you mentioned that you have to look at some of the state laws. So would this question also apply to specific states, but maybe it's broad enough that you might be able to help our viewers?
Correct. The strongest way to go against the creditors will be the irrevocable trust, the domestic asset protection trust. And in this kind of trust, we have to do some sacrifice. Unfortunately, we have to give up the rights to use the money. But we can control who will use the money. For example, I have two children. I like my firstborn, and I can see my firstborn will be the beneficiary. But after 1 year, my firstborn treats me not very well. I can say, okay, my younger child will be the beneficiary. In this way, because I give up the rights to use the money, so my creditors cannot pursue the money in the domestic asset protection trust for their claims. So that will be the strongest way for us to go against the creditors. However, we have to sacrifice the rights to use the money in the trust. And yes, different states have different rules. For example, if we are in Massachusetts or New York or most states, with the domestic asset protection trust, we cannot use the principal. Well, we can use the income. So it means, for example, we have a house and we have rental income from the house. With the house in the domestic asset protection trust, we can still use the income, the rental income monthly. However, if one day we sell the house, we cannot use the principal. But in California and New Jersey, they require us not to use both principal and the income to be qualified for the protection against the creditors provided by the domestic asset protection trust. And on the other hand, in most states, including Massachusetts and New York, they say you can be one of the trustees. You have to be co-trustee with somebody else because somebody else will supervise to make sure you are not abusing the money for your own benefits, but you can be one of the trustees. However, in California and New Jersey, you cannot be the trustee. You have to find someone else. For example, your adult children, your parents, your siblings, your friends, but you cannot be the trustee at all. So it is a case-by-case issue. And I always recommend my clients to refer to professional people before going ahead with the irrevocable or asset protection trust. Thank you.
With respect to finding somebody, it doesn't, I mean, obviously it doesn't have to be a family member, but do attorneys like to be named in trust to execute the trust, or is it just, are you just the executor of the trust on behalf of your client?
Usually, the role of a lawyer in the trust will be the person who will draft the trust documents. Usually, we don't want to be the executors or the successor trustees. The reason is very obvious because we cannot involve ourselves too much in the family cases, especially when we're not very familiar with the situations of the clients. So when they pass away, we have to find their families, we have to distribute the assets. It can be a lot of work. So we always encourage our clients to find their families and friends to be the executors and trustees to manage the assets. But in some particular cases, for example, I have a client who has 4 children with special needs. That's a very sad case, 4 children with special needs. And she is single. She doesn't have close family, so she cannot find a person who can be the trustee among her friends and families. I refer her to find a professional financial people in the big banks. They have the bank department called trust departments, which are specialized in managing the assets in the trust properties. I recommend them to find the professional financial service people to do that instead of the legal people usually. Thank you.
And are those fees comparable? I mean, we talked about how much probate costs, can be up to 15%. Are those fees as much as that, or it's usually lower just in general? I mean, I know you don't work for the banks, but just in your experience, what have you seen?
In general, if they find their friends and family as the trustees, it will be definitely much lower than the probate fee because usually the friends and families are beneficiaries. They don't really charge for managing the assets. And if they want to find the financial professional people to help with them, it really depends on how much they have. Usually, if it is the assets below $10 million, it will be around 4 to 5%. And if it is, beyond $10 million, usually it will be 1 to 2%. But if they have more assets, they can negotiate with the professional people for a discount.
Yeah, right. Well, still, it's a lot less than probate.
Yes,
a lot less hassle because the timeline, I would assume, tell me, you never want to assume, but it would be shorter.
Yes, because if we go to probate court, it takes them in general 1 to 2 years.
Yeah.
And New York and California, because of the population, usually we need to wait for 3 to 5 years for a case to be closed in the probate. And in the time, the assets will be frozen, so their families cannot really use the assets. But if we have a trust, if we pass away, our families and friends as trustees, they can take over the assets immediately and automatically. They don't even need to wait for 1 second. Yes, so they can make the time much shorter than the probate court process. Thank you.
Yeah, and we're talking about real estate today, but that I would assume would also be with respect to the stock market. If you have stocks, you don't necessarily want to wait 1 to 3 years to sell a stock or transfer a stock to a beneficiary if the market is going down, or if it's going up, that's fine. But if it's going down, you don't want to wait.
Yeah. Yes.
Yeah.
Yes.
Okay, here. So another question I have, I think you talked about the domestic asset protection trust. So can you speak to how irrevocable trusts protect your real estate and financial assets from lawsuits and judgments?
Yes. For the irrevocable trust, it is a way to isolate our assets from our liabilities. Basically, we give up the rights to use the money. And in this way, even if we have creditors, we owe money to others, or if we have judgment, the creditors cannot force me to use the money in the irrevocable trust to pay off the debts because we already give up the rights to use the money. And on the side, it is not only us, but also our beneficiaries, the people who will inherit my assets, will get the protection as well. So in this way, if we have children as our beneficiaries, if we have families or friends as our beneficiaries, the beneficiaries' spouse and creditors cannot force us to use the money to pay off their debts, even if when I pass away. So the money will be in the hands of the families instead of their creditors and spouse. So that is an extra bonus as well. Thank you.
A lot of states have something called homestead protection up to a certain dollar amount. How would a trust differ from that type of just, I kind of call it a regular protection that the state offers and the federal government offers. So how does that differ from the homestead?
Yes. So for a homestead, if you are homestead, it means you are the household owner and you have minor children or you have dependable people like, people with special needs as your family members to live together with your house. And in this way, because of the reason to take care of the family, if you have creditors, if you owe money to others, the creditors cannot force you to sell the house you live with other people to pay off the debts because in this way you don't have anywhere to live and your friends and your families like the minor children or the dependable people, they will be homeless as well. That is not human, right? So the creditors cannot force you to use such houses to pay off debts. However, If it is not a homestead house, for example, it's only a rental house, it is an investment, it's not my residential house, so I don't need it for residential purpose. And in this way, I cannot use homestead as a reason to go
Right,
against my creditors.
right.
But if I have the irrevocable trust, it doesn't matter whether it is homestead or not, whether it is rental or not, I can use irrevocable trust to avoid creditors. The reason is because irrevocable trust doesn't protect assets because my families need to live in the house, but because I give up the rights to use the money. So the creditors cannot force me to use the money to pay off debts. So my families can be the beneficiaries to use the assets. Thank you.
And so you've been talking a lot about irrevocable trust, but sometimes some of my clients have said to me in the past is that I want to put it into a revocable trust. So, or do you have any tips or strategies for people that they like the idea of a trust,
Mhm.
but they're uncomfortable with not being able to change it in the future because
Yeah.
maybe something happens,
Mhm.
and they don't know what life holds for them
That's
in
true.
5, 10 years.
That's true. I always say if you are not sure, proceed with the revocable trust first.
Mhm,
Because for revocable trust, we can still use the assets when we're still alive.
mhm,
And it can help us to avoid the tedious probate process. And the revocable trust can still protect the assets against our beneficiaries' spouse and children and the creditors. In this way, if we have creditors, the creditors can sue us to use the money in the revocable trust to pay off debts. But if we pass away, the money goes to our children. Our children's creditors or spouse cannot sue them to get the money from our trust property because the trust property will be only for our beneficiaries without interference of other people. And in this way, we can still get protection. Well, we can still use the assets when we're still alive. We are very flexible. And only when you are 100% or even 120% sure that you don't need to use the assets in the future, it will be only for the benefits of your family in the future. So that's the time when we can have the irrevocable or asset protection trust to isolate the assets from our liabilities. But if you are not sure, if you are thinking about perhaps I want to use the assets in the future, please proceed with the revocable trust first. Because once you have irrevocable trust, you don't have the right to regret your decision. And in the future, if you have the revocable trust, you can always change it to irrevocable trust. You can always give up rights later on to get protection. But once you have irrevocable trust, you cannot go back. So it is a one-way road. So please always proceed with the revocable trust if you have any doubt about whether you need to have the irrevocable trust to give up the rights to use the money. Thank you.
and can you sell a piece of property that is in an irrevocable trust?
Yes, you can.
You can.
But once you sell that, you have two options. First, you can buy another piece of property in the name of the irrevocable trust. For example, you sell the house in the irrevocable trust and you open a brokerage account in the name of the irrevocable trust and transfer money of the proceeds in the brokerage account. Second, you can transfer the money to the beneficiary's name. For example, my irrevocable trust beneficiary is my son. And if the house is sold, I can transfer the money to my son's bank account. But you can never put the money in your own account anymore. It
Mhm.
cannot be your individual account. So short answer, yes, you can sell the assets in the irrevocable trust. Well, you cannot use the assets. It has to either stay in the trust or go to the beneficiaries, your families or friends named in the irrevocable trust. Thank you.
Oh, yeah, that's good information. So, Link, could you talk with us a little bit about what happens if you have somebody in your family that's a spendthrift and is just going to rip through all of your assets that you work so hard for? I mean, can you talk about how estates and trusts can protect against those types of devious behaviors?
Yeah, I know. When we want to give access to our families, like for example, our children, our siblings, we really want them to use the assets to the best extent because we
Right,
money
right.
so hard. We don't want them to be wasted, right? Yeah, I know. But sometimes we are always worried, especially as parents, we always worry about our children all the time, no matter how old they are. They are still like babies sometimes, right? We're
Right.
so worried, yes. So that's why a lot of my clients come to me to say, Lin, I really want my children to enjoy my assets, but I don't want them to abuse my assets. And I don't want the assets to cause trouble to them. Like I have a client who is a guy, and his wife passed away,
Mhm.
like leaving 200K from the life insurance death benefits for the children, like two children, one girl, one boy. And after 1 year, the son, went to the father to say, okay, I used up my money. I want you to give me some money. And the guy was very surprised because the son just got 100K from the deceased mom 1 year ago. So the father asked the son, so where did the money go? How did you spend the money? And the son said, I don't know how I spent the money, but I know I don't have money right now, and you need to give me the money.
Mhm.
That will be a sad story.
Mhm.
So I always tell my clients, our children, they face two risks. One risk is from outside, their spouse, their creditors.
Mhm.
One risk is from themselves.
Mhm.
And we can always use trusts to protect against the risks, no matter whether it is from outside or from the inside.
Mhm.
The trust is like us. We always want to protect our children.
Mhm.
Sometimes, even when we pass away, we still want to protect them.
Mhm.
But we cannot, we pass away. But we can still put our love in the trust to continue the protection for them. Because when the trust survives us, our families, our trustees, our beneficiaries' children, they can only follow the rules to manage and use our assets.
Mhm.
So on one side, we can say my assets will only belong to my families, my children. If
Mhm.
they have creditors, like if they have a bad car accident, if they owe money to others, the creditors cannot sue them for the money. And
Mhm.
if they get divorced, my ex-spouse cannot take the money away from my trust property because that is from my family, that is from my parents. They
Mhm.
say the money only belongs to me.
Mhm.
And on the other hand, we need to give them some regulations if that is necessary.
Mhm.
If they like to spend money, like the money is gone over one night, we
Mhm.
cannot give the money to them, like at one lump sum. We
Mhm.
can say, okay, every month you can use perhaps $10,000
Mhm.
or $30,000 from the trust property, or only when you are working for yourself, you can use the money. You cannot just rely on my money to support yourself.
Mhm.
And we can ask the reliable people to be the trustees to manage the assets. For example, our other children, our siblings, our parents, depending on the situation. So in this way, our children will not abuse the money, will not harm themselves with our money.
Mhm.
So the trust, the spendthrift clause, can protect the children from the outside and from the inside. And of course, different families have different situations.
Mhm.
So we always give them the customized situations, the customized documents to protect them to the best condition.
And so is that spendthrift language within each trust? It's like a very customized type of language that an attorney like yourself would provide?
The spendthrift languages will be always there. And I always talk with my clients about how they want the spendthrift language to be drafted. And
Mhm.
of course, we have some general suggestions. For example, the creditors and the spouse cannot touch the money. They are always there,
Mhm.
unless the clients need otherwise.
Mhm.
But for other things like per month, how you use the money, how you want to spend the money, I always talk with them because different children are different. And the different families have different expectations. Some
Mm-hmm.
of them say, okay, I want my children to use my money to start their business.
Mm-hmm.
So the children need to have the flexibility rights to use the money when they are younger. But
Mm-hmm.
some people say, I want my children to start up the business with their own money. There is no reason for them to use my money to start up business, right? They need to show their ability to start up business.
Mm-hmm.
But I want to make sure, like, if they get old, if they are not that successful, they can still have the money to support their late life. So
Yeah.
in this way, when they are younger, when the children are younger, they cannot use so much because they need to save for later. So I always talk with my clients to think about their expectations and draft according to their wishes.
Yeah, yeah. And so, are there other types of measures that you can take, say, for example, insurance strategies and maybe perhaps LLCs? That's been a big hot topic lately, especially out in California. Can you speak to that a little bit about other alternatives and why it's not a good idea or it can be complementary to the trust that we've been talking about today, or just your thoughts about it
Yes.
since you are the expert.
Yes, there are alternatives to asset protection besides trusts. And I always say there is no good or bad. You need to think about your situation. And
Mhm.
sometimes we need to combine all of the alternatives together to give us a strong protection. First, the LLC companies or Inc., right? It's a company anyway. Some clients ask me if I have a trust, whether I need to have a company. I say, definitely you need to have a company. Why? The companies can help us to isolate our assets from our personal liabilities. For example, a lot of people, they are landlords.
Mhm.
They rent their houses to other people and make a living with the rental income.
Mhm.
And if we just have the houses under our individual names, what will happen if a tenant has a bad injury in our house? We
Mhm.
need to take all of our money to pay for their injuries.
Mhm.
If the injury is serious, it can bring both our life and their life.
Mhm.
In this way, if we have a company and the house is owned by the company, what's the worst scenario? The worst scenario will be, okay, the company is broke. I give everything in the company to the injured tenant, and I can get myself off the hook. So that is isolation. I always say if you're doing business, if you're not living in the house yourself, but you are renting it to other people, if you're doing a business, always have a company. Even if sometimes it means you have a higher tax, but think about the situation when you get protection from the company. You can have the peace of mind. And then you can put the company in the trust. So if we pass away, the company assets will be inherited by our families and friends in the trust. So we can always combine both trust and company to protect our assets and leave the assets to the next generation. And of course, some people will say, okay, but I still need to put my assets in the company. And if something bad happens, the company assets will be gone. I want it to be protected like from the very beginning. Then you can choose irrevocable trust. In
Mhm.
this way, the creditors cannot do anything because you give up the rights.
Mhm.
But you have to give up the rights. And for company, you can still use the rights. So you need to balance the pros and the cons.
Mhm.
And the other way is the insurance. I always say we live on the insurance. If we go to hospital, the first thing popping up in my mind is whether my medical insurance will cover the medical expenses. And we have auto insurance for our cars, house insurance for our houses, a
Mhm.
lot of insurance, life insurance.
Mhm.
And we also can think about umbrella insurance. The umbrella insurance is a kind of insurance which can go against a lot of risks in our life. For example, suits.
Mhm.
And as a lawyer, I have malpractice insurance.
Mhm.
So if I do something wrong, of course, hopefully never not, but
Yeah,
if I do
right.
something, yes, but if I do something wrong, the malpractice insurance company will pay for the loss. So I don't have to use my own out of pocket money to pay for that.
Right.
So Insurance is another way for us to take a lot, like a little bit money to get a lot if something bad happens. So that's worth it.
Right.
And some clients ask me whether I should choose umbrella insurance or irrevocable trust. Because revocable trust, we know it cannot protect us against our creditors, but
Mhm.
irrevocable trust can. I always tell them whether you still want to use the assets.
Mhm.
If you think you feel comfortable to give up the right assets, yes, irrevocable trust will be good. You don't have to pay extra
Mhm.
to get the protection. But if you still want to use the assets, you cannot just put it in the irrevocable trust. Then what can we do? We can buy the umbrella insurance and to use the insurance money to pay off debts. It is much better than paying everything with our out-of-pocket money when something really bad happens.
Right.
So I will always say, if you want to get the total protection, and if you think, okay, I can give up the rights to use the money, choose the domestic asset protection trust, the irrevocable trust.
Mhm.
But if I still want to use the money, then umbrella insurance, or if you're doing business, a company is a must in most situations to isolate the assets from our liabilities. Thank
Yeah.
you.
Yeah.
Yeah.
There's so many choices to make, and it really does depend upon your family situation and how old you are too, because I can see how the revocable trust would be good maybe a little earlier in life when you're not really sure. Maybe you haven't finished having all of your children, or, whether you're having them naturally or adopting or whatever the situation is. But and then, when you get older, say in your 80s, things are sort of settle down a little bit, and perhaps the irrevocable trust would be the most appropriate form. It does really depends.
That's true. That's true. For example, I'm in my mid-cities. I'm not married. I don't have children. So I will definitely not choose irrevocable trust, right? Because if I choose irrevocable trust, what should I do with my own life? I still
Right.
have a long life, hopefully,
Yeah,
ahead.
right. Of course you
I still
will.
need to use the money, yes. And
Yeah,
on the other hand, in most irrevocable trusts, their children are the beneficiaries. They are the trustees. So they can use the money from their parents. But who
right.
can use my money because I don't have children yet?
Hmm.
So in this way, I will choose revocable trust to say if something bad really happens, my money will go to my parents without probate court process, and my parents can still use my money without interference of their creditors, their spouse, but I cannot choose irrevocable trust right now. But when I get older, when I'm in my 80s or 90s, hopefully, then perhaps I know, okay, this part of assets, I feel so comfortable that I will never use it because I am already old enough and I am financially successful enough, so I don't need to use the money. So
Right.
I can put it in the irrevocable trust to isolate the assets from my liabilities. So why not? It really depends. And yes, when we get older, the irrevocable trust will be more accessible for us. Yes.
Right, right. And it's always so it's kind of a touchy subject, especially here in the US, because I don't think anyone walks down the aisle when they're getting married thinking, oh, I might get divorced. But the thing is that when you buy such an expensive asset like a house, and perhaps you're both working, and it can get kind of touchy. So especially if you don't have children or any beneficiaries, so all of these different things you really have to think about. And I'm so glad that you came on to talk with me about this. Because our goal here at the First Time Home Buyer Workshop is to educate people and first time home buyers that they have options, and just taking one little nugget of information and learning. Um, but you've been so gracious today in providing your knowledge. Please, everyone that's watching, reach out to Lynn. All of her contact information will be in the show notes, and you can see she has a QR code as well up. So reach out to her. They're licensed in 28 states, and I'm sure if they're not in a state you service, you could probably refer somebody out as well.
Yes.
Yes, thank you so much for your time today, and I hope that our paths cross again soon.
Thank you so much, Julie, for the platform, and thank you everyone in front of the computers. Thank
Yes.
you.
All right. Thank you. Bye now.
Bye.